Okay, so today we're going to talk about what happens after you sign your trust, your revocable trust specifically. This is a video where I go over many of the most frequently asked questions posed by our clients. I'm Sonia Muñoz-Gallagher. I'm the founder of Family Wealth Law. I am an estate planning, probate, guardianship, and special needs estate planning attorney in Florida. And I'm going to go through answers to some of the most commonly asked questions that we get on a very frequent basis. So hopefully this video helps a lot of people. So one of the most common misconceptions that I hear is that once you sign your trust, you've completely finished. You're done with the process of creating your estate plan. This is not accurate. Think of your revocable trust as a lunch bag. You have to have the lunch in the lunch bag in order for the lunch bag to serve its purpose. So you put the lunch into the lunch bag by funding your assets into the revocable trust. So signing the estate plan is an extremely important milestone. That is how you execute the trust. That is what makes it valid. But after that, you need to understand that you have to make your plan work the way that you intended, which is probate avoidance. So today, I'm going to talk about that in more detail. So question number one, let's get started. The question that I'm going to go through now is my trust effective immediately, right after I sign? The answer is yes. Your revocable living trust becomes effective as soon as it is properly signed and notarized, also known as executed. And this happens at the signing ceremony. As long as you sign in front of a notary and you have two witnesses that are not beneficiaries or even family members, I'd prefer that they not be family members at all so that there's no question of bias later on, and it's properly notarized by a Florida notary, you now have executed your documents. That means that they are valid in the state of Florida. You remain in complete control of everything. You are typically serving in a revocable trust as your own trustee. So what does that mean? That means you can buy, you can sell, you can spend, you can invest, you can refinance, you can amend, and you can revoke the trust that you have just signed at any time while you are alive and competent. That is the key, competence. Nothing changes in your daily life or in your assets. The trust is simply a legal container that holds the assets and provides the instructions for what happens if you were to become incapacitated or pass away. You can download our free trust funding checklist using the link below. It's the same checklist that we provide to our clients after they sign their estate plan to help ensure that their trust is properly coordinated with their assets. So let's begin with question number 2. After you sign, also known as execute, your estate plan, your revocable trust, do you still own your assets? The answer is yes. Many people worry that transferring their assets into their revocable trust means that they no longer own them. That is not the case. You still own all of your assets and you still have complete control over all of your assets after you fund them into a revocable trust. For example, if your home is transferred into your revocable trust, you still have complete control. You can sell it, you can refinance it, you can live in it, you can rent it out, you can make repairs on it, you can put solar panels or a new roof or whatever repair needs to be done. It's still yours, completely yours. It does not accelerate the mortgage because it's your homestead. So these are also questions that come from clients. whether a lot of people want to know and worry, oh no, Attorney Sonia, is my mortgage going to accelerate? Am I going to have to pay off my house if I put it into the trust? The answer is no. As long as the house is your homestead property, it is protected. So that's one important thing that you need to know. Another important thing that you need to know, another question is, am I going to have to pay more taxes if I place or if I fund the trust, the revocable trust, by transferring my homestead property into it? No, you do not. The answer is no. Quite the opposite. The reason why you want to transfer your property, your homestead property in Florida, to your revocable trust is to save not only the probate fees and the probate conflicts in court, but also to give your beneficiaries the step-up basis benefit, which means that when and if they sell the property, that property is going to be taxed on the amount that it was worth at the time that you pass away, not at the time that you purchased the property. So what does this mean? Let's give an example. Let's say that you purchased a property in Miami and you bought it in 1996 for $100,000 and you still live in that property and now it's worth $1 million and you pass away next year. Next year, it's worth $1 million. Your kids, when they sell it, are going to pay taxes on the difference from the $1 million to whatever they sell it to, or for whatever they sell it. So let's say, for example, that they sell it for $1,100,000. They're going to pay taxes on the $100, not on the $900,100. That would be the difference between the original payment that you made when you purchased the property and the value of it at the moment that you pass away. So that's extremely important. And that's one of the incredible benefits of putting your real estate in a revocable fund, in a revocable trust, excuse me. So let's continue. Now we know the trust is simply another way of holding title. It does not affect your ownership or your control of the property. It does not accelerate the mortgage as long as it's your homestead property, and it does not affect your taxes at all. It benefits your beneficiaries, and that is why people use revocable trusts, aside from the benefit of keeping the beneficiaries out of court, because we know that can be litigious. I know that firsthand from being an attorney for this many years, over 20 years, and also working with a probate judge in chambers and seeing the ugliness that comes out of people when they're in court fighting over money. In addition to the mourning and the sibling rivalry and all the emotions that are there, it can get extremely and unnecessarily litigious, which at the end is way more expensive for the beneficiary. So we don't want to do that. That's why people use revocable trusts. Okay, let's see. Question number 3. Do I need to transfer assets into my trust? Yes, 100%. Absolutely. You must transfer your assets into the revocable trust. This is the most important thing after your documents are signed and notarized. Creating the trust without funding it is like building a safe and then leaving your valuables outside of it. It's like having a lunch bag for your children that you don't put the lunch into. So it doesn't have the effect. It doesn't work for what you intend. So depending on your situation and what assets you've got, the assets that may need to be coordinated with your trust are your real estate, including your homestead property. If you've got rental properties, that goes into the revocable trust as well. Bank accounts, brokerage accounts. If you own a business, your business interests, whether that's 100% or a percent because you've got partners, gets transferred into the trust, because that can be incredibly messy in probate matters. I'm telling you, as an attorney that has done it, it can get extremely expensive, all the while the business is at risk of bankruptcy. So you don't want that. So certain investment accounts also go into the trust. The funding is what helps your family, your beneficiaries, avoid probate court. So that's the point. Fund your revocable trust. And you can download our free trust funding checklist using the link below. It's the very same checklist that we provide to our clients after they sign their estate plans to help ensure that the trust is properly coordinated and funded for their assets so that it does what it's meant to do: probate avoidance, asset protection, distribution in the way that they want, protecting their minors or protecting their adult children from themselves, protecting them from car accident lawsuits, from divorces, from addiction or impulsive behavior, and incentivizing them for behavior that you want them to have. For example, if you want your children to go to university or to technical school or to any advanced education, those are things that you can designate in the actual trust. Or if you want them to have a small business and be entrepreneurs, all of those things are designed in the way that we structure the trust. And that is why you have to fund it, so that the assets go through in the way that you want, that you design with me. Okay, now let's talk about question number 4. What about my retirement accounts? Generally, retirement accounts are not retitled into your trust during your lifetime. Instead, we can review the beneficiary designations. For many families, beneficiary designations control who receives the account after they're passing away. This is why the beneficiary coordination is so important. So this is incredibly important for blended families, for people that are in a second marriage or with a domestic partner and perhaps have these accounts from years prior. You would be amazed at how many times people forget to update those beneficiaries. And at the end of the day, if those accounts are not properly updated, the individual that was written as a beneficiary, listed as a beneficiary, is the one to get those assets, even if they are not the current spouse. So you want to make sure that you do that correctly and just update everything in the way that you want. And you can go ahead and download our free trust funding checklist using the link below. It's the same checklist that we provide to our clients after they sign their estate plans to help ensure that the trust is properly funded with their assets, so that their assets can be distributed the way that they want, the way that is designed in their trust, so that it's protected and so that their beneficiaries don't have to go through probate court. All right, now let's go through question number 5. What happens if I buy a new asset after I've already signed the revocable trust? This is an easy one. If you purchase a new real estate property, all you have to do is deed it into the trust. You give me a call, we talk about it, I get the information, and we just deed that into the trust. If you sell your property, nothing needs to be done to the trust. It's just not in the trust anymore. So that's important for you to know. If you open a new account, if you acquire a new business, if you enter into a partnership with someone for a business, or you make a major investment, whether it's a business, a building, a commercial property, anything like that, you need to review whether that should be coordinated with your trust so that it avoids probate and is distributed in the way that you designated in your trust. Estate planning is really not a one-time event. It's an ongoing process, and your trust is a living legal document. So as your life changes, your estate plan should stay current and you should update it depending on what events happen in your life. Like we just mentioned, whether you go into a partnership with someone for a business, if you purchase a business, if you purchase a commercial property, if you purchase more properties for real estate investing, so for rentals, things like that, all of those things need to be deeded into the trust. And of course, you can download our free trust funding checklist using the link below. It's the very same checklist that we provide to our own clients after they sign their estate plans to help ensure that the trust is properly funded and that their assets are going to be distributed in the way that they want and have designated in their trust. So let's move on to question number 6. Where should I keep my original documents? Where should I keep my estate plan binder? Store them in a safe and accessible place. A fire-resistant safe is often a really good option. Make sure that your successor trustee knows where your documents are located. If you are going to store them in a bank safe, make sure to give a durable power of attorney to your trustee so that person is able to access that vault at the bank. Because if not, then we need to open a probate in order for you or for your trustee to get access to the vault, even though you have the revocable trust. So you don't want that. You want to have the estate plan in a safe in your home or at the bank. And at the same time, if it's at the bank, the trustee should have a power of attorney that grants that person access to those documents, to that safe. And remember, you can download our free trust funding checklist using the link below. It's the very same checklist that we provide to our own clients after they sign their estate plans to help ensure that their assets are going to be funded into their trust and are going to be distributed in the manner that they desire. So let's move on to question number 7. Who should I who should I give copies to of my estate plan? I typically recommend that clients provide copies of their incapacity documents to the people who need them. So incapacity documents are the healthcare directives, the HIPAA authorization release, the healthcare surrogate, and the living will. And the durable power of attorney can be given to the person that you designate on that POA as soon as you wish. You don't necessarily need to provide your entire trust document to everybody or anybody, but the durable power of attorney, the person that you designate, should have that so that is available if and when they need it. The right approach really depends on your family dynamics and your personal preference. And we all know that every single family is different. Some families are extremely open about incapacity and about passing away and about what they wish to happen with their assets. And that's admirable. And then there's others that are not. There are others that are very hush hush, that are very private, that for many reasons don't have the ability to have these types of conversations with their family members, or just don't have a family member that they trust. So they have a friend be the person they designate in the POA, or they have a professional fiduciary to be the trustee. And you can download our free trust funding checklist in the link below. It's the very same checklist that we provide to our clients after they sign their estate plans. And it helps to ensure that your assets are properly funded into your revocable trust so that they are distributed in the manner that you wish. Now let's talk about what happens if I become incapacitated. This is where many trust-based plans provide tremendous value. If you become unable to manage your affairs, your successor trustee can step in and manage the trust assets according to the instructions that you've created in your revocable trust. Your durable power of attorney allows your chosen agent to handle the matters that are outside the trust. So these can be so many things. And the durable powers of attorney that we establish for our clients are very comprehensive, and they apply to families and to business owners and to real estate investors. So that's why they're customized for that individual person's needs, because if you're a business owner, it's not going to be the same thing as a mom and dad that just have 2 kids. So aside from that, your healthcare documents, the healthcare directives, allow your medical decision makers to communicate with the providers to make the decisions for your health and your treatment on your behalf. These are the HIPAA authorization release so that they can have access to your medical records, so that they can request from the specialist and then bring it over to another specialist or to another hospital. Because unfortunately, when you are dealing with different specialists from different health care providers or hospitals, basically, they don't communicate. And I can tell you this is extremely complicated and very stressful and just adds more to your plate. I have a 101-year-old grandfather, and my mother takes care of him. And I help in every way that I can. And I have taken them to doctor's appointments, etc. And I have personally witnessed how difficult it can be to get access to records when you don't have the healthcare directives, and how difficult and complicated it can be when you have specialists for different issues that come once we start aging, and getting them together so that you've got the list of medications, you've got the list of treatments that have been done, you've got the list of appointments that have been made, things like that. So you want the healthcare directives. Without the proper planning, families often just face chaos, and court can be extremely costly, time consuming, no doubt, and can be extremely emotionally stressful. And that's without litigation. With litigation, it's just emotionally exhausting for the families. So you can prevent this. How? Having healthcare directives to make the life of your caregivers and the people you trust a lot easier, to make it easier on them to help you, and to give yourself a voice so that even when you're not able to speak for yourself, it's written. And that person that is the advocate for you can advocate for you, can do what you wish. So these are the documents that you want to preserve your integrity. You want HIPAA authorization release. You want a living will. You want a healthcare surrogate designation. And you most definitely want a durable power of attorney. The durable power of attorney is what prevents a guardianship. If you get dementia or become incapacitated later in life, once you have a durable power of attorney, you are protected from a guardianship. It makes it a lot easier for your caregiver to make decisions on your behalf, for your agent to help you, and not make it necessary for you to lose all of your rights, which is what happens in guardianship proceedings. So let's go to question number 9. What happens when I pass away? What happens to my trust? What happens is simple. Your successor trustee follows the instructions that you left in the trust. If it is funded correctly, there is no need for probate court. Your family does not have to go through court. Depending on the assets that are involved, the trustee can gather the assets, pay the final expenses, handle any tax matter that is due, distribute assets to the beneficiaries in the way that you have designated in your trust, continue managing the trust for the children or loved ones that you have mentioned in the trust. And then for properly funded trust assets, this process is much more private, efficient, smooth, and way less costly. So a revocable trust is the way to go for families that wish to keep their beneficiaries out of probate court, keep their assets away from creditors, keep their life insurance protected from any lawsuit or creditor that comes after them, and be able to control the way that the money and the assets are distributed to their children so that it doesn't go to them as a rainfall when they turn 18, because that's what happens in probate court. When they reach 18, they get access to everything. And we know that's not a good idea. Okay. I'm going to answer question number 10. How often should I review my estate plan? I generally recommend reviewing your plan every 3 to 5 years or sooner if any major life event occurs. So what's a major life event that would require you to review your estate plan for changes? Birth of a child, death of a child, divorce, that's a humongous one, marriage, death of a beneficiary that you listed on the trust, a significant increase in wealth. I work with a lot of physicians. I work with a lot of professional service providers, and they come to a point in their life where they are generating a lot more income. And that is a wonderful thing, but also the time for them to come and speak to me immediately so that we can create a trust that protects those assets in a much better way. It's a different structure when it's an asset protection trust. There's many different types of trusts, and they have different levels of complexity, different levels of design, and different attorney's fees. So while some are used for probate avoidance and protecting the children, protecting the adult children from creditors, addictions, and potential divorces, it's a spectrum basically of protection. So it can start with probate avoidance and it can go all the way to asset protection, where the person is willing to lose control over the assets in order to have a very strong asset protection and tax benefits. And that's for a very different video. So just know that there's a lot of different trusts and that you need to update them and keep them up to date. Your plan just needs to evolve as your life evolves. That's what you need to know. It's one of the most powerful tools available to help protect your family, avoid unnecessary court involvement, and provide clear guidance and instructions during your incapacity and after death. But remember that signing the document is only the first step. Funding your trust, keeping the beneficiary designations updated, and reviewing your plan periodically are what help ensure that your plan actually works the way that you intended to when your family needs it the most. If you have any questions about your existing estate plan or would like to create a comprehensive trust-based estate plan for your family or your business, you can contact our office at info@familywealthlaw.net. I'm Sonia Muñoz-Gallagher, the founding attorney of Family Wealth Law, and I'll see you in our next video.